Honor. All right. Is the state ready to proceed?
Yes, Your Honor. State's requesting bail in the amount of $40,000 without a 10% cash option, with a no contact order, a no weapons clause, testing for alcohol, and supervision by Department of Alternative Sentencing. His allegations of using a nail gun, shooting a nail gun at his wife while the defendant was intoxicated. He scores a 7 on the MPRA, indicates he gets points for employment and lack of residence. His criminal history is as follows. So there's a 2021 misdemeanor conviction for violation of the domestic violence temporary protection order out of Reno Municipal Court. Unfortunately, I don't have victim information on that, so I'm not aware of whether it's the same victim in this case or a different one. However, I would note that he was ordered or sentenced to specialty court in that case, and he was revoked from specialty court. Prior to that, he's got a 2014 misdemeanor conviction for driving under the influence. What I would note is the PC sheet does indicate that when they look at his criminal history, it says multiple arrests for domestic battery, but no convictions. When we made contact with the victim, she indicated the same thing, that the defendant has been arrested multiple times for domestic violence in the past. We'll just note that the criminal history that I have doesn't reflect any of that. So there seems to be some sort of disconnect between what law enforcement was looking at, what I'm able to look at. Nevertheless, I think the victim corroborates at least what law enforcement is looking at as far as the defendant being arrested multiple times for domestic battery. So we were able to make contact with that victim, Miss Vickery. She did have a TPO. She filed for a TPO, and I see that that was granted given the allegations here. She indicated she's afraid for her safety, especially depending on when the mental state of the defendant is. Says she does believe that the defendant has some drinking issues, that he is manic. So if he's depressed, he drinks and tends to get violent or start these altercations. Other than on that, she does believe that alcohol is a concern for the defendant. So that's why the state's requesting, and also in the allegations here, that's why the state would be requesting that alcohol clause if he is able to post. Nevertheless, these violent allegations, as well as that history of at least violation of the temporary protection order, and given the victim's concerns, I think the defendant has shown he is a risk to the community as well as the victim. I would ask for that $40,000, no 10% cash option.
All right. Do we have a response?
Yes, Your Honor. As the state pointed out, my client did score a moderate on the pretrial risk assessment tool. We reached out to his mother, and she was able to provide some information that I believe will reduce that score. First, she was able to advise us that while he has been living at his current address for around 7 years, he is welcome to come and live with her where she lives locally. And so he will have a place to go that is not with the alleged victim in this case. She also was able to verify phone number and a little bit of information about his employment situation. So he was working steadily in Silver Springs, doing some kind of construction type thing, but now he's working on and off for a private contractor doing welding. So while he doesn't have a steady job that provides him with health insurance or benefits, he is working on and off. The other thing is that she gave us a little bit more information about my client's mental health. It appears that they have been worried that he has a drinking problem for quite some time. She said that he's welcome to come and live with him as long as he's not drinking. My client indicates that he's willing and able to remain sober and to be on drug testing and alcohol testing, if that's what will make the court comfortable. He's also able to wear a continuous alcohol monitoring device to ensure that he is not consuming alcohol. The other thing that she mentioned is part of what's going on, and this is something I think that the victim pointed out to the state, is that my client has some mental health disorders. Right now, given that he's not employed at a job that gives him health insurance, he is not taking medication, but his mom indicated that she's willing to help him with that. She's willing to help him as long as he remains sober and compliant with the court's orders. So it sounds like he has quite a bit of family support. It does sound like there are other circumstances that are going on that contributed to this that the court can mitigate with supervision and with testing. And given that those are in our, what we submit to the court today is that there are less restrictive means to keep the community safe, to ensure his return to court and to ensure that he is complying with court orders. other than incarceration, we would request that the court consider releasing him on his own recognizance with some conditions. He should live at his mother's house and not, obviously he has a TPO, so he can't have contact with the victim anyway, whether the court orders it or not, and he can't go back to that house other than with a civil standby to go get some of his tools and personal effects, but he will not have contact with the victim. He will stay at his mother's house and he can wear an ankle monitor to ensure that he doesn't go where he's not
You want to
supposed to.
give me, I'm sorry to interrupt, you want to give me the mother's address and her name?
Her name is Christine. What's her street address?
336.
Isn't that where your wife lives?
No, she lives at
I'm sorry.
30.
That's my mistake.
So,
I looked at I'm sorry, looked at court services notes, they had indicated Belford Way was where you were living. So I assumed that was where your wife was living, so let me make that change. All right, did you want to add anything before I make my decision?
so just, Your Honor, the GPS monitor and constant alcohol testing is our request today.
Understood. Bail is appropriate in this case. So it's going to be $30,000 with the 10% cash option. He'll have no contact with Rihanna Vickery or his children, nor may he go to 3030 Acacia Way. He'll be fitted with a V-check device before release. He'll be subject to testing. Shall not use or possess firearms. Must live with his mother, which is Christine at 3365 Belford Road. And he'll be subject to supervised check-ins. All right. Okay.
Get back to you. Do it.
Thank you very much.
All right, next is Ronnie Bailey.
Your Honor, Mr. Bailey indicated to pretrial services that he would retain private counsel, but he wishes to be assessed for the public defender's office at this time.
You assigned him.
I already signed him.
Oh.
Based on, based on my review of the file. So he does have a public defender. Obviously, if his lawyer retains a lawyer, that lawyer can file a notice of appearance. Is the state ready to proceed?
Yes, Your Honor. State's asking for bail in this case, amount of $7,000 with testing and supervision if he's able to post. The bail amount, I understand this is a driving on the influence allegation as well as a hit and run allegation, but the state believes that his criminal history is showing he's somewhat of a flight risk as well as the allegations here. So this goes to 6 on the MPRA. I understand it's a moderate. However, it does, when looking at his criminal history, it does show there's a non-extraditable warrant out of the state of Georgia for a battery and obstructing case. 2022, he's got an arrest for being a fugitive. 2020, there's a felony arrest for robbery out of the state of Texas. The only disposition I have is that it was held. So I don't know the exact outcome of that case. Subsequent to that, there's a 2022 felony conviction for invading law enforcement out of the state of Texas. 2018 misdemeanor conviction for battery and obstructing. I'm assuming that's what that warrant is out of Georgia is for. 2012 misdemeanor conviction for driving revoked. 2006 misdemeanor conviction for driving on the influence. So the fact that he has that pending warrant out of Georgia, he was convicted of evading in the state of Texas in 2022, the fugitive arrest in 2022. And then we have a DUI here where allegations are that he caused that crash and then took off again at approximately 100 miles per hour. So I think that's all evidence of the defendant being a flight risk as well as a risk to the community. State would ask for that $7,000 with conditions.
All right. Do we have a response?
Yes, Your Honor. This is a blood draw, so we expect that blood will be back in a couple of weeks. We were able to reach out to his reference. Her name is Carla. That's his girlfriend. She verified that he has moved to Reno or has moved to Nevada. He's living in Fernley right now. And he's going back and forth between Fernley and Lovelock doing some construction type.
Core Rochester mine.
I'm sorry.
It's a gold mine. Core Rochester.
Oh, working at the mine there. So she confirmed that he is employed, which I think is part of what pretrial services was unable to verify. They were able to verify his phone number and not his address. We believe that that if Mr. Bailey were to be on a continuous alcohol monitor and prevent him from consuming alcohol, that would go a long way towards mitigating any risk to the community. I do understand that some of the allegations here, the failing to drive on the right half of the roadway and leaving the scene of an accident with property damage. My reading of the probable cause sheet was that the property damage was like a road sign. I'm not sure that
Yes.
there was another crash. So I just want to clarify that it didn't appear to be a crash with another vehicle. Although my client is well aware that, although my client is well aware that drinking and driving can be pretty dangerous. So we would ask that the court consider setting his bail at $1,000 bondable with a 10% cash equivalent and the conditions that we mentioned.
A bail is appropriate in this case. I'm going to set his bail at $5,000 or 10% cash. He will be subject to residential confinement. He'll have to be fitted with the device before his release. He'll be subject to testing. The other condition, he'll have supervised check-ins with DAS. I'm not comfortable about the employment and place to live, given court services notes. So if they can verify his employment and his residence before release and he posts, then he'll be subject to those conditions. All right, I need to know he's working and he has a place to live before he can be released. All right.
We're going back.
Next individual is Courtney Kraft. Ms. Kraft,
I need to.
followed by Daniel Cruz and then Russell Gardner.
Your Honor, Miss Kraft was really not well when I spoke to her. She's not well. If we could continue this a couple of days and maybe she'll be feeling better by Monday.
All right, so we'll bring back Ms. Kraft on Monday. How about Daniel Cruz?
Mr. Cruz is present.
And then Russell Gardner, and then Timothy Evanson. Okay, is the state ready to proceed?
Yes, Your Honor. State's requesting bail amount of $10,000. This is allegation of the defendant essentially swinging at or hitting or being hostile with law enforcement at the jail there. This is an ad book allegation. He scores a 10 on the MPRA. He was just sentenced on the 18th of this month to 60 days jail on a brandishing deadly weapon case. Prior to that, he has a 2022 misdemeanor conviction for violating a domestic violence temporary protection order, 2021 gross misdemeanor conviction for destruction of property, 2020 a felony arrest for violations of conditions of release, 2020 he's got a misdemeanor conviction for drawing a deadly weapon in a threatening manner. I would note that in that case multiple bench warrants had to be issued. 2017 misdemeanor conviction for drug paraphernalia, 2010 gross misdemeanor conviction for conspiracy to utter a forged instrument. All in all, that he's got some other history in the late 2000s, early 2000s. Nevertheless, here what I've shown is that there's that history of violence, recent history of violence, recent history of non-compliance when released, and we have violence here. So I think some bail is necessary and appropriate due to community safety, but ask for that $10,000.
All right, do we have a response?
Your Honor, as the state pointed out, my client is serving a 60-day sentence. He's going to be in custody anyway. He doesn't have any money that he can post towards his bail. There is not an amount that he can afford. I wanted to make the court aware of that before allowing the court to set a bail.
All right, so this bail is going to be set at $5,000, 10% cash, no contact with the deputy. Von Bronk, I believe it is. He'll be subject to testing, shall not use or possess firearms, and he'll have supervised check-ins per DAS if he's able to post. All right. How about Russell Gardner?
Your Honor, my client has a very high bail out of the Second Judicial District Court, so he is not present and he will submit to the state.
Okay.
State's asking for $10,000.
All right, $10,000 it is. Additional conditions will be drug and alcohol testing, shall not use or possess firearms, and supervised check-ins with DAS. All right. Okay, how about Timothy Joseph Evanson?
Similarly, Your Honor, my client has a no bail hold out from parole and probation, so he will submit to the state's request today.
Right,
State's requesting $100,000 with supervision, testing, no firearms, and I've already said supervision. Thank you.
all right, so $100,000. It'd be subject to drug and alcohol testing, shall not use or possess firearms or weapons, and supervised check-ins with DAS. All right. How about Jacob Akoa? Followed by Samuel Pollock. All right, is the state ready to proceed?
Yes, Your Honor, state's requesting bail in the amount of $40,000 with supervision, no contact with the adult victim in this case. There's allegations of pandering as well as child endangerment. He scores a 7 on the MPRA. The pretrial service seems to be unable to reach his references at the time of his arrest. His criminal history, I showed 2020 felony arrest for child abuse as well as attempted residential burglary. However, that was dismissed. Prior to that, I see 2014 misdemeanor conviction for destruction of property. So we have serious allegations here of the pandering, as well as bringing his 4-year-old son to at least outside the location of that alleged pandering or that alleged date that law enforcement was able to set up. So I think the defendant has shown he is a risk to the victims in this case, would ask for that $40,000.
Right, do we have a response?
Yes, Your Honor. As the state pointed out, my client was arrested in 2020. All of those charges were dismissed. His only conviction is for destruction of property in 2014. He scored a 7 on the pretrial risk assessment tool, but we were able to reach out to the reference that he provided to us, who confirmed that he has been living in Reno for over 10 years, and provided us his street address as well as a good phone number to reach him. Confirmed his address. He is working for Lithia Hyundai. He has rent that is coming up due on the 1st of the month. He is a father to 4 children. This is his, the other person that is alleged to be involved here is his wife. They've been married for some time. And she is a stay-at-home mother. So she doesn't have any income if he is not released. They're pretty worried about what will happen if they can't pay the rent. It doesn't look like CPS is actively involved in this case. So for all of these reasons, we are requesting that the court consider releasing Mr. Ochoa with any conditions that the court feels are appropriate. He indicates that he needs to go back to work, that he will comply with any supervision that the court sets him. He will come back to court. He has no history of failing to appear. His personal information is verified. So we believe that he is actually a pretty good candidate to be successful on supervised release.
So his wife and children live at 240 Brooksby Lane, is that accurate?
Yes, Your Honor. That is the family's address.
Does he have an alternative place to live?
I could go to my uncle's house or something.
Okay, he has family that lives locally that he can go live with.
All right, just bear with me here. All right. I do believe some amount of bail is appropriate in this case, so I'm gonna set his bail at $10,000 with a 10% cash option. There'll be no contact with Teresa Ramos or his children. Be no contact with 240 Brooksby Lane, Reno. He'll be fitted with a V-check device before release. And he'll be subject to supervised check-ins with DAS. And before his release, pretrial must verify that he has an alternative place to live. All right, and that must be done before his release. It looks like CPS was not involved in this case, which is an additional concern. All right. So assuming he can bail, they have to verify that he has an alternative place to live, and it'll be subject to these conditions. All right. Next is Samuel Pollock.